Mr. Chairman, we were not expecting to be this far in the agenda, so we told the HSP folks that if they got here at about 10 o'clock, that they'd be in plenty of time. We could start without them, or we could wait.
Let's start without them.
I was going to say, can we take 15 minutes if you have, and give us a chance to look at this
Absolutely.
document, because this is the first we've had a chance to see it. And I just wanted to see how many buildings and other things that we've got stuck in here before we vote on it.
Would you like me to recess till the 5 to 10? Yep. That works? Yep. Do you want to sit here and...
It'd be nice if we had the time to do this.
Take a recess.
We'll reconvene at 5 to 10.
Before we do that, there's copies for the public if anybody wants copies of the latest. The latest.
10 minutes, it might change it again. Just kidding.
I hope to the
Okay,
better.
we're going to take a recess till 5 minutes to 10.
Thank you.
Okay. Bring the meeting back to order. 9:55.
Thank you, Mr. Chairman. The topic today is the contract with HSP Resources, Inc. regarding the sale of surplus property in the Erlong area to HSP. At board's past direction, making the following recommendations to approve the resolution or adopt the resolution approving the sale of the surplus property, which is in your packet, and also authorizing the chairman to execute the purchase and sale agreement, which is in your property, and authorizing the chairman to execute a quitclaim deed and other documents as they may be required to effect the sale, and to direct the staff to file with the county clerk recorder secret notice of exemption forthwith. And perhaps we'll take up a little out of order, but we'll take up the purchase and sale agreement first. As directed by the board, we have made changes to the draft agreement, and I'll point specifically to those as we go along. Item 6.3 on page 5 of the document deals with airport land use compatibility plan, and as the board is aware, HSP has offered as part of their negotiations of the purchase of this property to reimburse the county for the cost of preparing a airport land use compatibility plan. Our staff has contacted Mead Hunt and is in the process of negotiating a contract with them to perform that study at a cost of an estimated $48,000. And this paragraph deals with the reimbursement of that plan. It will be done outside of escrow. Once the plan is completed, HSP has agreed to reimburse the county for up to $48,000 for that plan that's going to be conducted by the Airport Maintenance Commission. Item 6.4 is the next item that I'd like to discuss as part of the most recent due diligence on our part of determining the property. I asked staff to go out and identify a legal description for an easement that will be retaining to allow for access to the substation parcel. As part of doing that, and I thank Malcolm and the staff of the road department for going out and doing that in a hurry. They determined that some of the points that were used in the Stantec map record a survey that was used to convey the property from the Army to the county were in error to a degree of maybe 30 feet and maybe as much as around 15 acres. And so we added a section in here to put the buyers on notice that that's the case, that there's an error in that map. And of course, we're only conveying to the buyers what we have through a quitclaim deed. So to the extent that that property wasn't conveyed to us, it would not be conveyed to the new buyer. That's what that paragraph deals with. There may be some follow-up action recommended by our surveyor as far as a notation or something on that old map, just to put others on notice that it is an error. Let's see. The legal descriptions have been attached as both to the property that we're conveying and to the property that will be conveyed back to us, being the B2 parcel. Both the county surveyor has reviewed those and concurs that they describe the property which was represented in the graphic in the RFP and what is intended to be conveyed. I guess for the record, Malcolm can jump in here if you want to. These legal descriptions were taken as a base from the preliminary title report that was obtained through Chicago Title, and I think some minor changes and corrections were made to that in coming up with the final legal description that we will be conveying. The legal description for the B2 parcel is Exhibit B. It is described through a parcel map, for lack of a better word, parcel B2, which is exactly what was conveyed to HSP in error last time. Council may have some other comments regarding the document itself. I will point out this document does include a referee clause, much the same as the past one.
Identical. Nothing in particular. I just kind of feel compelled to note that I know that there was an error the first time around. I wasn't paying attention too much to that. So handful in other areas of county business, but did note that perhaps that was an error that we made and didn't discover. I will note that the error that was discovered in the Stantec map was an error that we didn't make, but that we detected. And so I think as I commented some period of time before, there's quite a bit of effort being dedicated to a review of the legal descriptions that are part and parcel of this. That's not the right proper expression to use in this context, but that are part of this transaction. It's quite a bit of an effort by the surveyor and by the Director of Planning and Building Services associated with the Correctness Center. And so, that's what. I don't have to answer any questions in particular about the contract and the returns thereof.
I think, Mr. Chairman, speaking of errors, it's just a matter of probably for Jeff's benefit, if nothing else. When the Army transferred the parcels to the LRA, more than just this Stantec error that we're now discussing, we're just now aware of, but there were a number of errors in terms of the parcels and parcel descriptions. There were actually two properties. One of them was that the gymnasium building, and there was another, I can't recall, there was another piece as well, which was prime assets for the Army that they, in error, made in terms of transferring. I think it was done by quitclaim deed. It wasn't done by the grant deed.
Correct.
But so every time you use a quitclaim deed, you just kind of pass on whatever cumulative errors of preceding that particular transfer goes on to the next owner. And the county, when it became aware of that, the Army asked for the properties back, and the county, I guess, could have taken the stance that HSP did with the B2 property and said no, and maybe used it as leverage to acquire other properties, but the county did return those parcels to, the Army, because, we basically operated on good faith that we knew what they were supposed to be transferring to us and vice versa. And I think it's important just to note that for the record, because the county has been lambasted by some quarters for lack of competency in these areas, and I guess if it's not that it's a defense for the failures of staff and the failure of the board to supervise staff, that they, when it comes to the complexities of these properties, I think there is a fair amount of competency challenges that, even across the country, even some of the best minds in the Pentagon even couldn't get it right. So I think it's just important to note that as a note on the side, a historical footnote to those particular proceedings. And that's what makes, I think, even more important that we get it right on this particular transaction, because I think that we've learned, not to trust what we see and what we hear is being promised. And I think we need to be honest about that in terms of diligently responding to it. And I would say that my skepticism for this whole transaction is jaded by that historic past. We come into these deliberations and these proceedings on the basis that we're trying to do good for the public. That's what we're here for. Try to conduct the public's business. And we get promised a lot of things by a lot of areas, whether it's, in this case, the buyers, or whether it's the staff or whoever may be promised by the Army, and only to find out that what is promised and what actually happens could be two different things, and the reality of that. And how do we protect and insulate the public interest from that reality? I think that's what we need to guide our actions today. And to be honest with you, I'm not convinced and not totally sold on what we're doing, because, and I read through this, buyers shall not be obligated to defend or indemnify sellers from claims and whatever arising that are attributed solely to the gross negligence or willful misconduct. That's in here. So, in terms of, so how do I know that we've got gross negligence or willful misconduct? How do I discern that? And am I able to guard against that and have to be indemnified from that? I just find, it's gotten to be that cynical. Interest acquired by the buyer is also subject to any limitations that may run with the land and not hearing evidence. I guess may run with the land. Yeah, I guess that's some sort of a legalistic term. I was a half miler in high school, so I could relate to what it was like to run with the land.
That's on the land.
In other words, it's kind of handed down from generation to generation. You see that reference, that phrase in here numerous times. At least, we were able to discern the error in the survey work from the Sandtech, and it shows you that even the private sector, the vaunted private sector, can make mistakes. It's not just the sole purview of the government folks who always make mistakes. So I don't know. Shouldn't have got up this morning. There is a reasonable probability that the transfer of the title of the airfield property will be consistent with airport land use compatibility plan being prepared. There is little or no probability of substantial detriment to or interference with the future adopted airport land use compatibility plan if the transfer of the title is ultimately inconsistent with the airport land use compatibility plan. That's a mouthful, but I see a couple double negatives and reverses. So how do we prejudge, the public process this way? I just...
Where are you referring to?
This is on the bottom of page 5. This is the last 5 lines of 6.3, the new language that you added in 6.3.
Yeah, I think the language you're referring to comes straight from the government code, whereby the Airport Land Use Commission in order to, for a project to go forward, this is deemed a project, the transfer of the title is deemed a project. The Airport Land Use Commission has to either determine that it's consistent with the plan or that substantial progress is being made towards a plan and that the project is not likely to be inconsistent with the plan.
It's straight out of the Public Utilities Code. That's language expressly from the statute 21675.1. And those are findings that have to be made by the Airport Land Use Commission. And so it's not something necessarily that I created
What's that
myself.
section again,
21675.1, I think it's paren C of the Public Utilities Code. And so,
Well, the reason why I raised that as part of the question, the monologue, is that, the plan is supposed to be developed based on the public input. You're not supposed to have any thumbs on the scale, but when I read that there, it sounds like we got thumbs all over the scale, that we've already kind of predetermined the outcome. Maybe the Public Utilities Code requires that. I just find that is not, I'm not saying that when the final word said that everything is fine. But
Well, I would, and I don't mean to be argumentative, but I think the project
that's okay.
I'm used to it, of simply transferring title is a fairly benign project, if you want to call it that. There's no land use change occurring, no construction occurring, nothing occurring other than the transfer of title. And so I think it would be probably reasonable for the Airport Land Use Commission to make a finding that simply the transfer of title is not likely to be inconsistent with the plan. Because I think it's unlikely that someone would say that the plan is going to say you can't transfer title. I guess is my point.
my reaction, Mr. Supervisor Chapman, is to deal with your expressed concern head on. And that is to recognize the complicated nature of what started out to be a fairly simple process. And to be precise, we set about the process some months ago of considering how it was that disposal of surplus county properties was going to occur. And since that time, a number of issues have been identified, like, for example, the prospect that this involves land that surrounds an airfield. It surrounds an airfield for which there is no airport land use compatibility plan. And what are the obligations of the parties in relation to having a plan? Whose obligation is it to have the plan, to pay for the plan? Who's going to prepare the plan? All of these issues, the surveys, the multiple parcels, the reservation of easements, funding from another source, taking back essentially a parcel that is used as part of the consideration for the transaction in the first place. And so while it may have started as a fairly simple proposition, that is to shed property that government shouldn't necessarily be in the business of holding, it has morphed into a fairly complicated transaction. And there are a number of issues in here that are memorialized in the 20-something page document. And memorialized, my preference is to set it out on paper rather than have something unspoken. I think it's important to try and anticipate what's around every corner as best you can. But I'll say it here and I'll say it now. We have seen on previous occasions how, despite our best intentions, we try and anticipate how something might go sideways and make allowance for that in the agreement that we strike. That we can't always, with 100% perfection, estimate that, calculate that. But we approach it with an eye toward anticipating as many possible things.
It does, and Bob always is good at that.
That's what you pay me
They
for.
call that a rebuttal. They call that a rebuttal.
I'm getting my money's worth.
After the board gets done with questions, then I'll get the question from the public.
I got a couple more questions. On page 8, you have title policy for the one-stop property, and it shows the total of the amount is $125,000.
Yes.
What was the assessment appeal for value placed on it? that property, I understand that this property is subject to an appeal from the assessor's office values, and we went before the appeal court, and I guess they met a week or so ago. but
Last Friday.
Yeah, what was the dollar amounts that they came up with for this particular part of it?
$125,000.
Okay, so I just want to find out.
That is the number that the assessor's office assessed the property value of, and that number was challenged at Assessment Appeals Board by the applicant/owners of the parcel, and the Assessment Appeals Board sustained the assessment determined by the assessor's officer.
Well, I was just concerned that maybe Richard was going to get serious assessed about it. Anyway, below
Checking to
that,
make sure that isn't mine.
below that, I have a question here, and I'm not sure that this creates a problem, but it's a curiosity. So, 9.2 general plan conformity. We're having to go through the process to dispose of the airport property. That has to go at some point before the planning commission.
It's already completed, sir.
Okay.
On both
And
accounts.
then it says the acquisition of the one-stop property is in conformity with the, as well.
Yes.
My question is, in the last sale, the RFP and the mistaken transfer of the B2 one-stop properties, did that go to the planning commission for conformity before it was mistakenly transferred?
I believe that the mistake also went to the planning commission. I believe so. That legal description, so yes.
It would be kind of tough to get an acquisition conformity back when we didn't get a disposal conformity in the first place. I just kind of wondered how the planning commission reconciled those inconsistencies. Even the mistakes got vetted. Yeah, for now.
Okay, Aaron?
Yeah, I'd like to go back to start with you. We were talking about the survey. If you go back to Exhibit B on the very last page.
Yes.
When you read that first sentence, all that real property located in the northeast quarter of Section 2 and the northwest quarter of Section 1 in the East Township in the range of
Yes.
Essex County. As I read that, the northeast quarter of the section is 160 acres, and the northwest quarter of a different section is 160 acres. 320 acres we're looking at.
This is a description that was provided to me by the surveyor and or building and planning services, maybe an answer.
And we're talking about legal descriptions. I mean,
Yes.
it says all that real property located in. To me, that says 160 acres. In the northeast quarter of Section 2, that says 160 acres.
More particularly described as follows.
Mistake, we're grabbing more than we're supposed to be.
The operative phrase is more particularly described as follows.
Yes, sir. Well, shouldn't that be a portion instead of saying all that
Yeah.
real property?
What is, if you read it literally, it says all that property with that phrase, more particularly described as follows. So it's talking about all the property is what's particularly described as follows. The way I read it.
Mr. Barry,
I could respond to that, Mr.
Come
Mulbauer.
up
Yes,
recording, country recording,
Okay,
take it
excuse me.
in for the recording. Want to be sure all this is recorded.
So we want to make sure that.
Malcolm McDowell, County Surveyor. That's a good point, Mr.
We'll
Mulbauer.
be taking back all the town of Hurdle.
You're worried about that.
That is a word.
I don't think we want that.
Take the one stop out of it.
We'd just be taking what they'd be needing.
Okay, go ahead.
Okay. That could be written either way. I could say that all that real property being a portion of the northeast quarter, but it's located, the section line goes through, kind of touches that part of the property, and that's such.
The important point is, we're talking about the contract, not the deed. Okay, we're talking about the contract, and the contract is, the question is, does the contract specifically enough identify that which we're negotiating or agreeing to convey and or accept, in this case accept, because it's that, the two parts of that. Does it correctly identify it enough such that if there became a dispute later about the terms of the agreement, that we thought we were going to get more, or we thought we were going to get all of Herlong back? I'm satisfied, based on my conversations with the surveyor, even though I'm not a surveyor and I don't do survey work, but that this correctly identifies enough for purposes of the contract, and more than enough, such that we know what we're getting. Sure.
Well, I mean, we got Rachel and Nicole once over this in scrutinized pretty heavily
Yes.
once before. And when I just saw that, I mean, that was a great big red flag to me, and it can be very easily interpreted to cause a bunch of problems.
Well,
In my own personal opinion.
the beauty of this whole process is that I brought this agreement on my thumb drive today. And if there's a desire from the board to change a particular portion of it, that can be accommodated, because that's part of this process. I'm satisfied in the manner in which this is described. I think the surveyor is satisfied as well, that we know what parcel it is we are essentially asking you to agree to exchange.
Right, and I understand that from the surveyor. I mean, it's not saying the entire 160 acres. Of that 160 acres, the parcel B2 has shown what they're talking about.
Yes.
Yes.
It's clear to me after it's been explained to me.
Well, I still think, I don't like all that real property located in. I think
It has to be all that property. All the property we're talking about is in that section.
Yes, and then you read the next paragraph down.
Right.
It clarifies the first paragraph.
Exactly.
If you put a portion, take out all that and put a portion of the real property, then it's not all the real property located in the northeast quarter of section
And
2.
all that refers to the next sentence, next paragraph.
Next paragraph clarifies the first paragraph.
Actually, the last line is more particularly described as follows. All that real property, more particularly described as follows. You know,
Yeah, only that is described as false. Not the whole 160 acres, but within that 160 acres, the property is described as false.
Right. And
But
that's-
when it describes it in the next paragraph.
Clear to me.
Well, if that's the case, then, you know, what you're suggesting there is correct, then we need to go back to Exhibit A and amend it to reflect all that whole property, because there you talk about portions and so forth, in the manner in which Mr. Alphonse raised in the question.
If you change, and this is all semantic, but if you change all that property, all that real property to a portion of that property, what you're saying is a portion of parcel B2. If you read it further. And that's not what we want.
you can interpret it that way too.
That's not what we want to say.
No, I think we ought to leave these to the surveyor. I mean, obviously, I'm not a surveyor, and I don't understand all of this, and we have to.
Can you change the term real property to parcel, so that you can?
No. No. Has to be, you're describing property as located within the northeast quarter of section 2, the northwest quarter of section 1. More particularly described as follows. You can't say all that parcel located in the northeast quarter.
One of the first sentences to say that the property we're talking about is located in these sections. And then the second sentence is more particularly described as that property.
Good question, Aaron, but I think it's okay.
I could probably,
Trust me.
Mr. Alban could probably prove 10,000 legal descriptions are written this way.
I'm going to take the advice of the surveyor.
Thank you.
And if he's wrong, how do you deal with that? We're going to take questions from the public in a minute. You want questions from, okay, go ahead.
I have a map, a parcel map of B2. My understanding, the way it's written, is that we're getting a building back and not the entire parcel. Is that incorrect? We're getting a $125,000 building back. They're not giving us back that 1,900 acres.
Well, they include the property.
I mean, 19,
1.95.
1.950.
Hopefully we're getting more than just a building, hopefully we're getting a little bit of ground to go with the building.
Well, if there's doubt, why don't we clear it up? Because B2 is more than a $125,000 building.
It's described in the legal description. Parcel B2 is what we're getting at.
It's specific, 1.95 acres.
More or less.
So the building sits on 1.9 acres.
Yes.
I would assume that by what
More or
the
less.
surveyor.
Well, we can't assume, Bob. Is that correct? The building sits
I
on
have to
1.9?
take, I have to take the knowledge of the surveyor. I'm not a surveyor, so I'm not even going to attempt to say that's correct or you're not correct.
The building is located on parcel B2.
Thank you. Okay, Larry, more questions?
That's it for right now. We'll go ahead and,
Tim? Tom? Yes? I'm good.
you come back in again
Anybody in the audience have any questions? Mr. Spencer, when you come to the podium, and state your name.
I'm Spencer, CammyHelp.com. I have a question, a few questions, and then I have a handout. When Herlong was sold, the RFP was purchased by an individual, Steve Pizzulo, and the deed was done in Steve Pizzulo's name. With this document, you have a RFP that was awarded to HSP, but you have a singular person signing the document that doesn't state HSP. Do we need to put the HSP to clarify we're not selling it to Jim Chapman? Who is part of
Would you answer that question?
We understand that,
Or a CAO?
we understand that Mr. Smith is an agent of HSP. He's here to comment on that, and that's the way the contract has been set up.
Well, it says the buyer, and the buyer is HSP because that's who you awarded the property to. Whether Mr. Smith is or was a partner can change any day, but the award was made to HSP Resources, and you have the buyer is Larry Smith. So will the deed be to Larry Smith because he's the buyer, which would be the correct way, or would the buyer be HSP Resources and deed made to HSP Resources?
Sure. The contract contemplates HSP Resources, Inc., which is a LLC. We have been informed by HSP that the notices, the agent for notice is Larry Smith, at the address listed on there. The signature block does not contain a name, but it will have to be verified at the time of signature. Whoever signs it can do so on behalf of HSP LLC.
And the second part of that is, will the deed be to Larry Smith, or will the deed be recorded as HSP Resources?
The deed would be to HSP Resources LLC.
Good.
Second part.
Second part, part two.
Part two. There are a lot of attachments to this handout. I'm just going to read a little bit and then I have another comment. All of the documents have AMADE, A-M-A-D-E, airfield, and there is no such place. It's misspelled throughout everything. There is a AMADE, A-M-E-D-E-E, airfield in Herlong, California. In 2003, Sierra Army Depot provided a legal description of the 3,576 acres that was given to Lassen County. The county included this Exhibit A in the request for proposal issued on September 23rd, 2014. However, the new Exhibit A you have included with the sale agreement has three major flaws. Number one, and I visited the assessor's office this morning and got, I think it's been added to the back of your, the last exhibit attachment is what I got this morning from the assessor's office. I like consistency, and when you say in a document Eileen or Janice or Bob, Spencer, probably one of those things are right, and it should be consistent. But
I'll be consistent now.
but
Which
this
would you
doc,
like, Eileen or Elaine?
just don't call me late for dinner, Bob. You
Okay,
know the rules.
We're running out of time for good.
The inconsistency one is you have recorded in book 38, page 42, the maps, and that's in the original recorded survey from the Army. However, you've got, throughout the document, you have everything but that language. So it just, somebody didn't pay attention when they were retyping the document to be consistent with that language. Second, the county voted to keep, I know this is important to Mr. Chapman, to keep the end of the parcel of the runway. However, the APN that's used in your legal description includes only APN 133-080-60. Now, this parcel number wraps around like a backward C, around the airfield. I confirmed with the assessor that there is no parcel number for the piece that Mr. Chapman wanted to keep. Therefore, that parcel that you're offering for sale does still wrap around the airfield. So you are selling it. It is included in your which it wasn't supposed to be, but if the documents stay the same, then you are selling that end piece of the airport that you want to keep. 133.0856 was not included in the graphic that has all the parcels identified. It's not there anywhere. So the assessor said that if you look at the page behind that, the assessor says that it's that little corner up here, which is part of the wraparound. And talking about how diligent, I'm assuming Mr. Burns and Mr. Egan have reviewed everything, but throwing caution to the wind, I appreciate Mr. Chapman's concern that something like this could happen again. But unless you go back, and there's a fix, unless you go back to the assessor's office and give that end of the runway a parcel number, in fact, you are selling it in this document. And there's no way to get around it except to assign it a parcel number and exclude it.
Okay, thank you. Anybody else? In the back of the room,
Let me
Mr.
come back
Knocker.
up. I'd like to respond to Eileen's comments there. On page 19 of the document, that top paragraph, also accepting from that portion of the empty airfield parcel as described in the supplemental agreement, that is the lease area. So we're accepting that out of the parcel. 100%. Okay.
Thank you, sir.
There is some people have the misconception that property is conveyed through a parcel number. That's not the case. Assessor's parcel numbers are simply assigned by the assessor for the purpose of assessment. They have nothing to do with title, although sometimes that could turn out.
Anybody else in the public? Everybody happy? Okay, Aaron?
To tie into the supplemental agreement number 1, is that included in here, or where would that be located at?
Top of page 19. That's the lease area that's described in that document.
Okay, all that real property is described in that supplemental agreement number 1. Where is that? Where would you find supplemental agreement number 1?
You find it in document entry number 2013-00350.
Okay.
Anybody else?
Okay, you just have
a question, maybe Malcolm could identify, since we have this graphic that's part of Exhibit B, I guess it was from the RFP, with that 30 feet where that sand tick, where is that specifically on the maps that we're looking at here? It could amount to up to 15 acres when you run 30 feet.
Can I see what you're looking at?
Well, I'm just,
On the exhibit there?
the exhibit that she had in the handout she gave, so I'm not sure in relationship to the
Okay, it's
airstrip.
basically the north line across the Amity airfield parcel.
This parcel right now, this one.
Yeah. We're only transferring properties that are within sections 20 through 27, or that section, or 20 through 24 across that north line.
So the description in the deed that we got from the Army to the LRA was 30 feet shy of that section line, which is where the description was given.
If I would, go ahead, please.
I just want to understand it.
No,
Because-
it's an excellent conversation to have, because.
Well, the reason being is I'm convinced that the referee clause is going to be exercised at some point over this disputed 30 feet. So I just kind of want to know now rather than trying to find out later what I should have known now.
Understood. And so, the Stantec survey was, as I understand it, not the actual legal description that was included in the deed from the Army to the LRA when these parcels, and they were conveyed at different times in different transactions, but it was referred to as a document upon which some parties and or future parties could rely. In the Stantec survey, and we're talking about those sections which are sections 20 through 24, if I understand it correct, that's 5 sections in that range and township and range, where in the survey only, not in the legal description associated with the deeds, but in the survey only, the northern property line was defined by relying on the witness marks rather than on the section lines themselves. And the effect of that was to essentially move, on the graphic at least, the northern boundary of those parcels up by about 30 feet across the 5 sections. And that's an exceptionally thin strip of land over that distance. And so Malcolm correctly identified that the Stantec surveyors had made the mistake when they created their survey. And so what we're saying is that when we acquired 20 through 24 in the first place, we acquired it by quitclaim, and that was that the Army conveyed to the LRA, conveyed to the county, nothing more than they had to possess in the first place. And so to the degree that the Stantec survey made an error, we still acquired no more than that which they had to give. And that's essentially what we're saying, and the reason that was included in this contract was, hey, look, you need to know on the front end, before you ink this, that there is the possibility of an error in the Stantec survey, and just as long as you know, because you've agreed, essentially, HSP, to take these parcels by way of quitclaim, that we're giving no more than that which we had in the first place, which is what we acquired from the LRA, which is what we acquired from the Army. Interestingly, and it's a twist associated with this particular transaction, I think that HSP and or maybe another entity that they do business with, I don't know, owns the parcels on the north.
They do.
And so if there is an issue with that, if what we're giving them more than there's a dispute about it, they're going to acquire a dispute with themselves. That's how I view that.
For the entire length.
Yes. Now, I'm not certain if it's the entire length.
My understanding is the parcels that Mr. Pazul supposedly acquired only are on the northwesterly side of what would be the airfield parcels. It wasn't the entire length all the way back to the road. I mean, there's a significant piece of property up there, but it wasn't the entire length.
I don't know the specific response to that fine point, whether it carries all the way to the east or not. But I believe at least, and maybe they can speak to this,
Well, I can. Actually, it's actually from the northwest corner of section 21 east. I did review the map and with the GLO plan of 1942. And the north line of section 20 is okay. For everything from the northwest corner of 21 all the way to the Magazine Road, I discovered they used the one line notation.
But that's not the question. The question is does HSP own those sections and all of them,
I have not.
such that if there's an error that they're now on notice of, if they ink this deal, that they're essentially buying a dispute with themselves? Do you know the answer to that, sir? If they have
That's a
all of
legal
those
use question.
sections.
It's a legal use question.
No, I'm just asking,
Yeah,
who
that's
owns
legal.
those sections north of the airfield
Well,
property?
they own it. They own that over there. You know, they actually own to the south line of their sections to the north, and they're only getting from the county to the north line of section
So-
21 through 24.
So the response that I have is at least some of those sections 20 through 24 are bounded on the north by property, and I think first in the northwest section by parcels that are owned already by HSP, and to the degree that they own to the east of that. And I'm uncertain about that specific question. They are essentially buying a dispute with themselves. But if they don't own all of them, and any parcels to the east of that, I am still convinced that we are only conveying that which we have a legal right to convey in the first place, that which was conveyed to us by the LRA and by the Army in the first place, and that is north of the section line only, and not beyond the section line as far north as the witness marks. Sir.
Okay?
To tie into that, you've got the access road going across there. Is this going to encumber that access road for the easement at all, this property line dispute?
No,
Doesn't involve.
They didn't come down far enough.
no, yeah, we're quite a bit south of that.
And to be clear, I don't necessarily accept the premise that it's a property line dispute, right? Out of an abundance of caution, we have included in the contract language which is essentially a notice clause, a notice to the prospective buyers that in a survey that was previously commissioned by the Army, not the county, by the Army, in anticipation of the transfer of these properties, they made an error, and that the parcels which were conveyed may, at least to the degree that the survey was relied upon, may be relying on the witness marks and not the section lines. I don't necessarily accept the premise that there's a dispute at this time, sir.
Good. I have a question for Mr. Egan. In the last go around with the RFPs, one of the criticisms that underwrote the fact that we mistakenly included properties that weren't intended to be included was the fact that we had a lack of graphics of the maps and so forth that related to what all the legal descriptions relate to. So, you know, for lay people to be able to sit here and look at what a legal description of a parcel is, it's kind of difficult to do. I mean, you can follow through and kind of, you know, in your mind try to create it, but having the graphic to say, this is the parcel, even though we have a question about this northern line here. And I find in the stuff that was provided for the board by staff, there's no graphics at all included. And now we have a graphic that's been presented by someone in the public, which obviously was taken out of the RFP files and stuff. We had some graphics there. So my question is, why didn't we include graphics with this so we could try to see the two and maybe even have a bigger size one rather than just the small, you know, little maps we have?
We could do that. We did include a graphic in the RFP itself.
Yeah.
And that graphic is, this legal description is a representation.
Of that graphic, and I guess the point I was making is I think the board at the time, you know, made it clear that as the process went through, that when we have these documents presented to us, and more importantly to the public to review, to assist us in reviewing, that we would have the aid and benefit of both the written version and maybe a graphic picture version, so that we could hopefully have a greater appreciation of what it is that we're doing. And up till now, we've been able to see that, but all of a sudden, it just dawned on me when I'm looking at this, and I don't want to dispute the credibility of the individual at the podium that presented this, but I'd much rather and would have greater comfort if I had graphics presented to me by staff or those in an official capacity rather than somebody in an unofficial capacity.
And Mr. Chairman, I know you presented a question to CEO Egan.
Is he deflecting it to you?
No. He can answer for himself. But from the lawyer's perspective, I'm reluctant to. I'll do what you want. All right, generally speaking, you're borrowing trouble, in my view, if you include a graphic and the written legal description. We know in
How do we
because
make trouble?
the opportunity exists for disparity between the two, and to the degree that
Well,
you have
but
disparity,
don't you
between
think
the
that the disparity between the two should be of prime concern to the board in making its judgment? I mean, you're talking about a 30-foot potential problem area with the Sandtech stuff there, and I think having a graphic where you could say, okay, this is the line, this is showing, ... this is where the Sandtech line is, these are where the witness corners are, this is where the section line is, and confusion can be brought about by that. I think having that presented in a graphic form as part of this here would aid the decision-making process rather than jeopardize it. I guess I don't.
Mr. Chairman, Calvin, do you need a graphic today?
Well, I don't need a graphic. I'm just saying is that in the past the board, in reaction to the debacle the last time, made that point is it would have been very nice, and the board and the county, the board was sharply criticized for the lack of having that clarity. And I'll take the lash, but now we're at it again, and if we're going to take any more lashes, I would just like to say the record to show that the board was not provided that graphic as it had been requested earlier. I mean, we're talking about 2 years ago. And that if the decisions are made and if there's any problems with the decisions, the board made it without the benefit of that. And I just share that as an observation. I don't think it should be a basis for stalling. I know the board's going to make the decision it's going to make. I just want to make sure the record is clearly understood so I don't get taken to task again for that same failure.
You don't need that today before we vote.
Well, I'm going to rely on what the generous public brings in terms of having a visual, and the questions I have in my mind I can generally get resolved there. I'm just disappointed that I had to wait for that.
I haven't seen that graphic, but if it came from an RSP, it probably contains the error from the Sandtech map, isn't that correct?
Well, the graphic from the RFP, the graphic on the RFP was, we took the section lines, so we drew along the section lines.
Oh, okay, so
Okay, yeah. We used the section lines.
The scale of that isn't going to, correct me if I'm wrong, isn't going to
No, I
depict
gotta
this
show that.
30.
Show that. No.
Any more questions from the board before we?
Well, you don't know how if the buyer is the only one buying the dispute themselves, or if there's other parties that potentially is involved.
Well, we didn't show the sort
It
of
doesn't matter.
neighboring.
It discounts it anyway.
Aaron?
Yeah, on page 17, it's 19.17, the headline is the natural hazardous disclosure statement.
Let me catch up to you as soon as I can. Page, I'm sorry, what?
17.
Yes.
Who prepares that, who validates it, who's responsible for doing it, and who's going to be held accountable, and who's doing it, et cetera? I've never heard of that before.
We've done that in the past. The county would prepare that for the property we're transferring. The HSP would prepare one that they're transferring to us.
What is it? Is that just like?
It's a disclosure. If there are known hazardous conditions, they're noted.
So that's like your asbestos, your chemical storage, your contaminated ground.
Yeah, I don't have it in front of me, but yes, it's all.
Potential obvious visual folks, okay.
No.
And who does that?
We do.
Who's we in the county? I mean, is that the health department or the building or?
Yeah, we'll planning staff prepare it.
Okay.
Just like we did with the property we transferred.
Okay, my next question is there mineral rights do we have mineral rights on this, and do we want to keep those? I think we should keep them if they're available. I think we should retain them in Wacom. And the reason why I say that is, and I didn't see it in here again, but I know when we look going through the RFP that there are certain parcels out there that there can be no soil disturbance below 12 inches. Yet I didn't see that in our contract sales agreement. Is that somewhere in the deeds, so we're eliminating problems? Is that going to come back and bite us? I think it should be in there.
Well, again, we're quick claiming simply what we have. Those are recorded conditions that the department placed on the property.
And they can stay with the property.
They run with the land.
I was gonna say, running with the land, going back to that phrase there. Yeah.
Has a specific legal meaning, sir.
Yeah, I
Yes.
didn't realize something as simple as that could be.
And then, as far as the one-stop, I mean, is it still less reasonable wear and tear? Is the condition of the building and the property still the same?
I am informed that, yes, it is, but I haven't personally seen it. But I'm informed by staff that it's essentially the way it was a year ago.
Because I think it needs to stay that way. And then the other question I have is on page 2, under number 2, in the third line down in the parentheses, number 2, you're talking about the airport land use plan. Either the adoption by the Lassen County Airport Land Use Commission of the Airport Land Use Compatibility Plan within the meaning of the PUC Code section, or adoption by the Lassen County Airport Land Use Commission of a resolution that includes a finding approving the action within the meaning of the public code. Can somebody explain that to me, please?
It's complicated. So, the county is obliged to have airport land use plans in place essentially for all airports within the county. And we now know that we're also obliged to have an airport land use compatibility plan in place for the amounts of the airfield properties. The land surrounding the airstrip itself, I mean, this is no surprise. This is something that we've been discussing for months. And it's Public Utilities Code Section 21675, etc., that requires that. There is an exception to that, and it says that if you don't have a plan in place, an action can still occur on the property surrounding the airstrip if certain findings are made by the Airport Land Use Commission. And those are set forth in 21675.1(c). And so you can get there essentially two ways: to observe your obligations required by law, specifically set out in the Public Utilities Code. And that is either to have a plan in place or to reach a stage of making essentially substantial progress towards the adoption of a plan. And that's what's in the .1(c) provisions. Sir, did that answer your question?
Just the wording of that.
Oh, it's complicated.
Yes,
It is.
It's terrible. And then if we go on over, I think it's page 6.
Yes.
Yeah. We're talking about the 48,000.
Yes.
It says up to and including 48,000.
Yes.
And then you go on down to the next paragraph for the first 48,000.
Yes.
And then it goes on for 48,000 behind that. I mean, it's not a lot of consistency because you have up to and including 48,000, and then later on you have to for the first 48,000.
But it is.
And then it goes.
And let me tell you why it is. Because although we've been provided what amounts to a cost estimate by Mead and Hunt of $48,000, it's plausible that it exceeds that. And so the buyers have agreed to reimburse the county up to $48,000 towards the preparation of that plan. And if it is some number short of that, then great. Then they don't give us 48, they give us some number less. But if it costs more than 48 because Mead and Hunt encounters some issues they didn't necessarily anticipate, the buyer's only on the hook for 48, and we cover the difference. Sir,
Okay.
does that answer your question?
That clarifies it. I was just.
And that's the understanding that I've been operating on for some time, and
We tried to get a blank check from them, but they wouldn't do that.
or want to go there.
And the other thing that I would like to see put in here is I would like to see some performance standards put in here. so that the property just isn't gonna be, because I mean, if we were just gonna give this away for a pittance, I mean, I would have been more inclined just to donate it to the college or something like we did the building for the VFW. I mean, so let's, you know, there's been talk about what great good this is gonna do, and it's gonna do great good. There should be no problem putting performance standards in the contract to make sure this gets done for the citizens of the county and the residents down there if they need something. So it's just not gonna sit down there and be vacant and be a pipeline.
And Mr. Supervisor Albaugh, I thought we had crossed that bridge some months ago.
We had, and I still.
The vote was 3-2.
The vote was 3-2.
I
I'd still like to see it put in there again. I'll just bring it up for consideration.
I drafted the document in the manner in which the majority of this board spoke, sir.
So anyway, that's my personal take on it.
And my personal take is I would severely be against it, and I would fight it on it. The government has proven they cannot take care of it. Look at the land the college has. You know, what would they do with it?
Yeah, the college already owns a piece of land out there.
How about the old county hospital?
I think the college sold that.
Did they sell it?
Yeah.
But, I mean, that's just going backwards, there's all it's doing. We want to put it in the hands of the private sector and let capitalism take its place. If they do nothing with it, then that's their choice. It's their land, they own it.
Last thing is.
And am I going to tell you what to do with your land? No, it's their land, they own it. If they want to make $1 billion, that's their choice. If they don't do nothing, that's their choice.
That's all I'm saying, to get something going.
No.
That's what we're doing this for, is, that was
I
part
mean,
of the reason for
I- I
selling.
would-
Weston County's owned this property for 25 years. You and I inherited this from,
11 years.
I started in 1990.
County
So-
didn't get it until 2004.
Let's
The
focus.
discussion goes back.
But anyway,
But anyway, it's not gonna go anywhere.
it wasn't us, we weren't supposed to make any money on
I
it to begin with.
just want to say, Mr. Chairman, I used to always kind of get a chuckle out of the farmers fighting over water. And You tell
That's not funny.
You tell Mr. Alba that you'll fight it. It seemed that you kind of fight it between two farmers. It's
Well, you know, obviously, one last thing is the government has proven, and like Mr. Hemphill said, we never was intended to keep it. We should have moved it on.
Let me.
But I just leave it to the private sector to now do what they want.
Right, and that's what we want. We want to see some
We
development.
put conditions on it.
Let me address that issue if I could, Mr. Chairman, because I think it's absolutely right. First of all, the county never was intended to be the developer of this property. That was never what was sold to it. Staff, we had staff at one time, I would say current staff recognizes the fallacy of their predecessors. Took that after we accepted it on that premise, and they took off in a different direction. And with all these pipe dreams that they had, I mean, their pipe dreams rivaled the pipe dreams of the private sector. And I think, they drugged the county through. It cost us $750,000 of subsidies, $50,000 here and $70,000 there over a period of about 10 years. So I think it is something that needs to be handed over to the private sector. We haven't had it since 1995. We've been talking about it since 1995 with the BRAC process. It took the Army 9 years in order to go through their process to dispose of the property. We basically have had responsibility since about 2004. Now it is 11 years later, and it would be, once we got rid of the staff that had the pipe dreams, and now we, can proceed ahead. I'm in favor of disposing the bulk of the property. My problem, and I stated it from the get-go, and it hasn't changed now, is that I'm totally opposed to giving it all 100% to just one particular, putting your eggs in one basket. And experience has taught me, whether it's in the private sector or the public sector, that kind of monopoly or control does not serve the public interest. I'd be in favor of granting everything except for this upper corner, as I talked about here last year. And I lost that battle on a 3-2 vote or 4-1 vote. They're retaining that, in terms of public ownership, and see what these folks do. Give them a first right refusal. If they make something wonderful happen out there, then fine, maybe transfer them the ballots and give them first steps on it. But I think to give it all at once isn't going to do it. But again, I watched the 747 land out there the other day, and I want to see a lot more 747s land. And, if the board proceeds with this here, hopefully HSP will be able to turn that into reality, because
folks up to this point for the last 20 years have talked about that have yet to have that happen. It landed out there not because of the private sector or for that matter this county. It landed out there because of Sierra Army Depot, and I think we need to recognize that.
Okay. One last question, Ms. Spencer, then we've got plenty of time, so make it fast.
Once, two things. I'd like to ask again that Amity be spelled correctly throughout the document. That's not a big thing to ask for since he has access to it. And also I'd like to ask Mr. Hammond to recuse himself because he owns businesses out there which stand to benefit, and also the fact that he was meeting with one of the bidders who you awarded it to during the bidding process, which is really stinks. But I'd ask him to recuse himself and be
Mr.
honorable.
Hammond make his own decisions. Thank you. Richard?
Mr. Chairman, you might want to get this on camera. I partially agree with Ms. Spencer about the spelling. Anyway, it's spelled both ways in different documents. It's most commonly, from what we've seen, A-M-E-D-E-E, but it's also spelled A-M-E-D-E-E. So we may want to put also known as or something like that.
The Army, all the Army documents are AME.
So we may want to reference both names if council agrees.
If that's the pleasure of the board, that's fine.
In the legal description, I can parenthicate every spelling if it's.
And that's the operative document, is the exhibit which is attached, because the contract in all respects makes reference to the exhibit, and exhibits, I should say, which are essentially the consideration for it, and or the definition.
So legally, that's still on the exhibit.
Yes.
One other point I just wanted to clarify as we're wrapping this thing up is the board made a thoughtful and conscious decision after receiving the planning director's recommendation to dispense with doing a lot line adjustment and clarifying all these parcels and where things are, and a decision not to do the airport land use plan about 8 months ago. And that's why we're in this situation of putting this together now. I just want to point that out for the record, and somewhat defense of our planning director. The whole while has said, hey, why don't we do a lot line adjustment, do some of this research ahead of time. We did it the way we did it. I just want to point that out.
No more questions from the board. The chair will entertain a motion to adopt the resolution.
I move we adopt the resolution.
No, wait, is this the resolution? It's purchase and sale.
Well, both, there were four items, four actions.
It's all in the resolution. Adopted
It's all on the
resolution, which
agenda.
includes 1, 2, 3, 4.
1, 2, 3, 4.
Yes.
Hammond's going to vote. You have no honor, Mr. Hammond. No honor.
I'll take your criticism, Ms. Spencer, and I'll consider the source.
Mr. Spencer, you're my officer, out of order. We have a motion and a second to adopt the resolution, which includes 1 through 4 on the agenda. Madam Clerk, only 1 second.
Do we want to address the name thing?
Yeah, I think we should.
Yes.
So it's consistent throughout the document.
Consistent spelling. And if you can still, make it Andy or Amity, just like.
I think we got the RFP.
Not approval on,
I think Mr. He's asking for is, have a consistent spelling
Quite
throughout.
obviously.
But put in parentheses,
Also known.
also known as,
yes.
so you have basic
Cover
those spelling both sides.
Thank you.
Okay, we're clear on that. With that change, Mrs. Spencer, you're being very rude to the public and this board. Any more direction from staff? That would be included in the motion?
Yes.
And that second also.
Madam Clerk, would you pull the board?
To be specific, though, I want to make sure the motion is clear. Is the motion, Mr. Supervisor Hemphill, to all 4 items listed under the action requested section of item D2 of the agenda posted for today?
Yes.
Sir? Thank you.
With the addition of the stone.
Yes, understood. Thank you.
Supervisor Chapman?
No.
Supervisor Alba?
No.
Supervisor Hempel?
Aye.
Supervisor Hammond?
Aye.
Supervisor Tyler?
Left committee.
Again.
Chair votes aye. Motion passes. If you have no more business, I think that ends it.
Mr. Chairman,
Okay.
I just would like to ask, we approved the agenda this morning with the addition of during the memory of during the course of the meeting, I received a text message from both a family friend letting me know that Wanda Thomas Johnson, she lives in Johnsonville, passed away last night. So I'd like to ask that we add her to the in memory of this, if that's possible.
We can do that. No, next week.
I just wanted to advise the board, there's a conference call scheduled for Friday, April 10 o'clock. Have the information, but it's to deal with the governor executive order that was issued regarding the drought water. I think you may have already gotten it in the box. If anybody
Are you going to
does,
have that on the speakerphone over at the conference room or your office?
yeah,
What time was that?
at 10 to 11 on Friday.
Okay, no other business from anybody, we'll go adjourn the meeting.
Are you so disappointed in Tom?